Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, good morning, everyone. We are here again Tuesday morning at 10 a.m. here on the Bottled Business Sense show. I am Rick Moscoso, one of your co-hosts today, and on the other side I have Bill Bernard. How are you doing today, Bill?
I'm doing great, Rick. Glad to be here again for another show. How are you doing today?
I'm doing great. You know, I was always trying to keep up on trends, especially when it comes to photography and video gear. Problem is, the stuff that I look at, just like you with watches, is not everyday purchases. You know what I mean?
Yeah. Well, yeah, I know. That's why a budget always comes in handy, huh?
That's right.
Although we got to stick to the budget. You know, it's like we tell our viewers and listeners, you know, stick to the tips we give you. Well, the same challenges apply when you're trying to buy something for your business, or when you're trying to buy something for yourself, like me with my hobbies.
What's been up with you? I know you've been pretty busy these last couple of weeks.
Yeah, you know, I'm actually on call as we speak for trial in Santa Ana, and reported for trial on Monday, and now I'm on call waiting for the court to find me a courtroom. So it shows you, folks, the courts are crowded. And when you have a trial date, doesn't always mean you're going to go out on time. The courts have to find a home for you, and that's not always easy. So
it sounds like it's worse than being on jury duty.
Well, yeah, at times, because you're just kind of waiting, and you're you've got an hour to get down to the court, and you're essentially, you know, you've got other things to do in your business. But you can't make too many long-term plans, because if you're called in, you're called in. Now, if that goes on for a period of time, whatever time the court deems to be reasonable to them, well, then they'll issue an order and continue the trial to another date, and I may go through the whole thing all over again. But it's a trust contest. It's an interesting case. It involves a large estate, and I'm hoping to resolve it favorably in favor of our clients, and get this move it on down the road, as we say. How about with yourself, Rick? What's been going on with you?
Oh, always looking at new gear, you know, and gear seems to turn around every 2 to 3 years, depending upon what brand you're in, or that you've invested in. And I tell you, the stuff just keeps getting better and better and better out there. Better in a way for the regular consumer, because they can get really good high-end, video and camera gear.
Right.
Which actually is good for us, the pros, because it makes us get better, because we have to stay, several steps ahead of them, because they have access to this good gear, right?
Right.
So it's just a matter of being more creative, more innovative, trying to figure out better ways of doing things that the average Joe can't or won't do, right?
Right. Yeah, no, listen, I can only imagine some of the trials and tribulations that you have to go through on doing what you do, but nobody does it better. So with that, I figure we'll get into our show today. We've got an interesting topic, or I guess series of topics, and it revolves around contracts. And we talked about long ago that the foundation of a business attorney, and actually the foundation of any business, should be contracts. Whether you're talking about asset protection, estate planning, employment law, Your business needs are founded upon contracts. And so what I thought I'd do today is tell the folks that are listening and watching what contracts must be in writing, required to be in writing by law, why you should always have all of your contracts in writing, whether they're required to be in writing by law or not, and the important terms, the basic terms that you need in your contract overall, because the specific terms can be, are going to be particularized, as we always said, to your particular business. But there are certain basic terms that you need in your contract, regardless of what business you're in. So I thought I'd start out, Rick, by talking about the fact that most people don't really understand the world of asset protection and estate protection planning, other than to know that there's something that needs to be written down. Well, that's true, but you're not required to go get an operating agreement for your business and put it in writing, although you would be remiss if you didn't. You're not required to have an estate plan, okay, which has to be in writing, but you'd be remiss if you didn't have one. But let's talk about contracts that directly affect the validity of whatever transaction you're in. These contracts must be in writing. Number one, contracts involving the sale of real estate or any interest in real estate. You cannot sell real estate orally. It just isn't possible. I know that might sound kind of funny, but I need to talk about the ones that are required to be in writing, and I just simply can't leave one out because most people would presume that a real estate contract has to be in writing. Hey, some people might shake hands and want to sell a piece of real estate. Mm-hmm. I admire two people who trust each other that much to want to do that, but it ain't happening by way of law. The second would be leases of real estate that last longer than 1 year. So if you want to lease some real estate from somebody and it's going to last longer than 1 year, got to be in writing. Okay, so we can all imagine different property leases, whether you're leasing out a building, you're leasing out land for a particular use. If it's real estate and that lease is going to carry over for more than a year, it must be in writing. The other one that is very interesting, the third one that it must be in writing, is a promise to pay someone's debt. If you owe somebody money or an obligation and you promise to pay them back, it's got to be in writing. Okay, so you can see where that's going to cause some issues if it's not.
Yeah, expand on that a little bit for me. What?
Well, Rick, you owe me $10,000, and I want you to pay me back. I better have that in writing, or you're going to be able to renege on that handshake, so to speak. And that's just the way it is. So if you're going to enforce, remember we're talking about enforceability. So let's go through these first three again. If you want to enforce a real estate sale contract, it has to be in writing. If you want to enforce a lease of real estate for more than 1 year, it has to be in writing. If you want to enforce an obligation to pay a debt, it has to be in writing. So, yes, can you do these things or attempt to do some of these things without reducing them to writing? Well, I doubt if you're ever going to be able to do that in the sale of a real estate transaction. But certainly with a debt obligation, you can agree upon something, but you're never going to be able to enforce it unless it's in writing.
And
Go ahead.
Sorry, I know we see this or we hear about it a lot, especially when a family member loans money to another family member.
Or a business partner.
Or a business partner. We see this. I'm sure you see this problem all the time and have to deal with that, right?
Yeah. And we've talked about in other shows what it's like to do. There's two interesting issues you brought up there. Number one, that it's not always the best scenario to get in business with your family. And number two, regardless of who you're in business with, if you have a partnership and you don't have a partnership agreement, you're not in the best of hands. You know, the old commercial, you're in good hands, right? You're not in good hands if you don't have something. This is central and goes to the core of what this show is. You should have your contracts in writing. So let's move. Excuse me, I apologize. Let's move on to the fourth area that a contract must be in writing. Contracts that take longer than 1 year to perform. So you enter a contract with me and you agree to do something in exchange for something I'm giving you. If it's going to take you longer than a year to do what you've promised to do, that contract has to be in writing to be enforceable. Okay? So something pretty basic and pretty self-explanatory. And then finally, the fifth area is the contract for the sale of goods or tangible personal property. The contract for the sale of goods or tangible personal property that's worth more than $500, or at least $500 or more. That kind of a contract must be in writing. So if you're selling something and the value of what you're selling to somebody, that product is $500 or more, that has to be in writing to be enforceable. Now, you can come up and shake my hand and say, yeah, Bill, I'm going to buy this $2,000 watch from you, and I'm going to pay you $2,000. I'll pay you next week if you don't mind. Would you mind giving me the watch now? And, of course, after I tell you where to go, Rick, I probably would I'm kidding, of course. If I gave you that watch at that time and came back to collect a week later, and the value of that watch obviously was $500 or more, I wouldn't be able to enforce that against you because it's not in writing. So
it's pretty straightforward stuff that you're talking about here, right?
Yeah, it is, and that gets into the second area that I think is interesting. To protect yourself for any business transaction, I would say, what's the best way to not have to remember these things? Anything you do in your business, put in writing. Put it in a contract and reduce it to writing. Because what was said, what was done, what's going to be said later on, or what's going to be done later on or not done, cannot be changed if it is by way of a contract. Now, you can have a clause in your contract that says you can make changes to the contract, but that all changes must be made by way of a written modification. And that's a good term to have in your contract. You don't want to modify a contract, a written contract, orally and expect to be able to enforce it. Any modification to what you already have written down needs to also be reduced to writing and added as an addendum to the original contract.
So let's go back to your watch example, and let's say you sell your watch to somebody. You sell it to me, and I make an agreement with you to pay you whatever you're selling it for. How complicated does that contract have to be, and could it be as simple as in the form of an invoice with just some simple T's and C's in the bottom of it? Or
sure, it could be. I mean, I wouldn't do it that way, but it could be because a contract requires three basic things: an offer, an acceptance, and consideration. So, if an invoice says, "I offer you this watch for $500 or for $1,000," and it's got the $1,000 on there, okay, and you sign it and agree to accept that offer, and that would be an offer and acceptance, and then we have the consideration, which is the money you're getting in the watch. You're getting the watch in consideration for the $1,000 you're going to give me. So yes, it could be reduced to an invoice, but we're talking about. I guess what I'm trying to do is get to transactions that happen in everyday business that don't involve something as simple as the sale of a watch. Then you should reduce it to writing. But to answer your question directly, Rick, yes, you could craft an invoice to be able to claim it's a contract, but you could also just write a one-page contract with 5 or 6 lines in it. Says, I, Rick Moscoso, promise to pay Bill Bernard $1,000 for this IWC watch, model number, blah, 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 no later than whatever date, or on the specific date you're going to pay. And both sign it and date it.
Okay. All right. Well, that makes sense. Okay. I think that in the context of what we're talking about, obviously we're talking about greater things in value than just a watch. We're talking about business contracts, business agreements, and that sort of thing, right?
Or though you can buy a good tourbillon for maybe $350,000, if you believe that. It's not something I'm going to invest in, but some people buy watches that are close to $1 million or $500,000.
Amazing.
It happens, believe me. So and some of some business owners, Rick, they're going to rise to the occasion when it comes to making, reducing their business agreements to writing. I mean, they're not going to just be lax. The real cream of the crop understand this, and they rise to the occasion, don't they?
Yeah, that's right. Well, this has been really enlightening and hopefully helpful to our viewers out there. But before we get into the back half of the show and hear more about written contracts and terms from Bill, why don't we get into share the information about our next sponsor here, and that would be Mr. Rick Regal with Edward Jones.
Yes, Rick Regal, R-I-E-G-L-E. R-I-E-G-L-E. He's a financial advisor at Edward Jones, and I've talked about Rick before. He's a great sponsor, very supportive of the show. He is just got a lot of great business acumen, specifically investment acumen, where he's going to be able to lead you down the path of investments that are fit into your budget. And he's going to be able to, by the way, he puts on seminars. He does end of the month coffee meetings where he actually does a presentation and an update on market trends and everything. He's just great to his clients. And he always recommends and references the particular estate plan that you need. So, okay, maybe you say you don't want an estate plan, but wouldn't you want a guy who refers you or recommends to you what he thinks you need? After all, that's what you're paying him for, right? That's what you need him for. That's the kind of guy I would want. And then if you say, okay, I'm going to hold off on the estate plan, well, I wouldn't advise you to do that. You may decide that it's something you have to do right now. But now you have that information that Rick's given you. So in any event, I would recommend Rick Regal for any of your investment needs. Rick can be located at 30110, that's 30110 Crown Valley Parkway, Suite 104 in Laguna Niguel, California, 92677. And his business number is 949 area code 249-8248. That's 949 area code 249-8248, and that's Rick Regal with Edward Jones.
Awesome. Okay. All right, let's get back to the back half of the show.
Yeah,
and Bill, you have some more to share with us?
Yeah, well, let's talk about some terms that should be in your contract. So we've talked about the contracts that must be in writing pursuant to law. We've talked about briefly the fact that business owners should reduce their contracts to writing all the time, regardless of whether they're required to do so by law or not. And now I want to talk about some basic terms. Now, I'm emphasizing these are basic terms that need to be included in most all contracts, regardless of what product you sell or service you offer. And the first one would be an indemnification clause. Okay? This is an important contractual term because it essentially shifts the burden from an innocent party to a responsible party who creates the liability. Okay? It needs to be inserted, and it needs to protect your business, and it needs to specifically state that any liability or loss that's caused by the action of the other party is going to be covered by that other party. Now, important here is a distinction to recognize. We're not talking about a blanket indemnification potential. What I mean by that is the law is not going to say, hey, you had the indemnity clause in your contract, and Mr. Bernard, you said that Rick will indemnify you for any and all things that he does that causes you liability. No. No. Rick would indemnify me for anything he does negligently that causes me a loss. Okay? If I do something, I'm not going to that's negligent or that's intentional just because I have an indemnification clause pointing to Mr. Moscoso. That doesn't mean that he's going to hold that I'm not going to be held liable, and then he's going to indemnify me. Okay? He's going to have to create the liability, and it's going to have to sound in some negligence. Okay? Or some intentional act on his part that causes me liability. But it doesn't mean that whoever causes the liability, Mr. Moscoso is the person who has to indemnify me. Okay, so I think that's pretty clear.
Yeah.
You'd be surprised how many contracts don't have this. The next one would be severability.
That's why we need guys like you to make sure
Well,
that there's everything's on the level, totally understood, and fair to both parties, right?
Well, things in life many times are relative, Rick. And what you would think is common sense may not be thought of as common sense to another individual. Why? Because your background and your training adds to what you already know to be common sense principles. So it's common sense to me that you would want an indemnification clause. It may not be to everybody who hasn't dealt with a lot of contracts or hasn't dealt with an attorney who provides them with sound contract advice. So, having said that, severability is important. If a contract contains an invalid term or a term in a contract is held to be illegal for whatever reason, severability clauses allow you to make sure that the rest of the contract is valid. So we have a 5-page contract, and maybe there's 3 paragraphs that are found to be unenforceable for whatever reason. Maybe they're against public policy or they're against the law. If those paragraphs are found to be unenforceable, the severability clause says, well, the rest of the contract is still enforceable. Because 1 or 2 paragraphs are unenforceable doesn't mean the whole thing needs to be canned. Okay? So a severability clause is very important from a practical standpoint for a business owner to include in his contracts. And, look, entrepreneur...
Let me ask you before you go on there. Sorry to interrupt. So, in addition to the severability clause, what if conditions change once the agreement has been made, and whether there's additions, deletions, they end up going a different direction with the project? How do you write those things into it?
Well, that would be by way of a modification. And remember, we talked a little bit before about the fact that modifications need to be in writing. So let's go on to the third clause, modification. You're going to want to have that modification clause in your contract that says, 1, you may modify the existing terms of the contract by way of an addendum, and 2, the only way you're going to modify it is by way of an additional writing, not verbally, where you're going to end up having a dispute because it's not reduced in writing to the original contract. It's not an addendum to the original contract, so whatever you modify orally is not going to be enforceable because people are going to look, the court's going to look to the original written contract, and if it's not in there, then there's no written modification, then it's your word against my word kind of a thing.
Mm-hmm. Okay, that makes sense.
Now, entrepreneurs, are not going to compromise their priorities on this sort of stuff. They're not going to second guess themselves. They're not going to compromise their priorities. They're going to learn new skills, learn new ideas, learn new things that they need to know to make their business run more efficiently. They're not just going to ignore this kind of advice. Okay, and again, separating the the wheat from the chaff. The cream is going to rise to the top. Entrepreneurs who really want to take advantage of this and who know that this is good, sound advice, they're going to grasp onto this, Rick, and they're going to make it a part of their everyday business activity.
Yeah, well, that's good advice, and that's I'm glad you mentioned that, because really it's all about creating a team around you that trusts what you're doing. Not only trusts what you're doing, but knows you know that you have somebody like yourself at their back to protect them against different things like this, especially when it comes to contract agreements. And not everyone's, the majority of us, entrepreneurs aren't going to know any of this legal stuff, right? And you've really got to take that into consideration. You've got to bring in the right people that can do that for you, so you can really focus on the things that you're good at doing to make your business run better, more efficiently, and more profitably, right?
Right.
So,
well, you mentioned an interesting point, Rick. You said some people or a lot of business owners won't know about this, but here's my retort, if you will, to that. Good business owners will know that they better investigate things and that they better check things out and find out what they don't know about. And any business owner who's doing business who hasn't had it flash in his brain, hey, I need a contract and I need it to have the right terms, is missing the boat. Not only do you need a contract, not only do you need the terms we're speaking about today, but thirdly, you need the terms that are specific to your type of operation, and that's where you specifically and more importantly go see a lawyer to gear it so it fashions your type of business. But in any event, the other term and the final term I wanted to bring to everyone's attention would be attorney's fees. Here we go, right? Many business owners who win court cases are disappointed with the legal process. Oh, heaven forbid. Really? I find that hard to fathom. And, geez, why do we keep saying we want to keep people off the courthouse steps, right? I mean, that's always what we want to do. Well, then they're left with a large legal bill. Oh, my goodness. I won this money, but half of it or a third of it or 3/4 of it are going to my lawyer. Okay? Well, if you have a contract that contains a provision for attorney's fees, it could indicate that if there's a dispute over the terms of the contract, the winning party would receive attorney's fees from the other party. So you can have a situation where you can contract to have attorney's fees. And in conjunction with that, you should have actually a fifth paragraph, because we've talked about what? Indemnification, severability, modification, attorney's fees. What about an arbitration clause? If you don't want to go to court, you might want to insert in there that you have a requirement to go to mandatory binding arbitration before a neutral third party. Now, the only problem I have with that sometimes is if you start going to an arbitrator in a private party, like a retired judge or whoever, that could get a little expensive. Could get a little expensive and might amount to as much, if not more, than the attorney's fees. However, if you have that provision in there and say that the losing party must pay attorney's fees, then whether you go to court or arbitration, you're able to recover your attorney's fees if you're the winner. Okay? So hopefully these types of things have emphasized not only the appropriate contract terms that you need, Rick, but the fact that the real seasoned or the real upcoming sharp entrepreneur who realizes that he has more to learn, not just in terms of his own business, but how to run his business, these type of people are not going to refuse to learn new skills. They're not going to compromise their values. They're going to focus on priorities, and one of those priorities will always be, hey, I need a contract, I need it in writing, and I need to have terms in it that are going to be beneficial to me, and I need to have terms that are specific to what my business does. And by the way, most often or not, these terms that we're talking about are beneficial to both parties, right? So if you insert it in a contract, there's no reason why a prudent business owner would have some objection to a clause for arbitration or attorney's fees or severability or modification or indemnification. Why wouldn't they want those things as much as you? But if they don't, or if they fall down and don't realize it, it's up to you to step up to the plate and make sure those things are included.
Yeah,
right?
That's right. And this is a great topic today because these are the things that successful entrepreneurs do to protect themselves and run their businesses efficiently. Because like Bill always says, you don't want to be wasting your time on the courthouse steps dealing with this stuff after the fact, because it could not only damage your business, but also take a lot of time to resolve if you haven't protected yourself properly.
Absolutely. Yeah. I mean, look, not everybody loves being in court as much as lawyers do. Let's be candid with the public here, because that's what I've always held my right hand up and said I would do, and that is, lawyers or litigators, not all lawyers, but litigators love the courtroom. It's exciting, it's fun, and they enjoy being victorious on behalf of their clients. And while they're there, they're making money. But a good lawyer, an ethical lawyer, will always make that the last resort and will do everything he can to keep his clients off of the courthouse steps. Why? Because they don't want to be there. And they're not making money when they have to spend their time in court, right? Mm-hmm. In fact, they're there with the potential of losing money. So, having said all of that, I hope that's been helpful to everyone today, and I think it's some real practical stuff that you can apply to your everyday business. Obviously, I'm always available to speak to if you need me, and Rick always has our information on a number of different places, social media, and of course our personal information, our personal websites. I'm at wfblegalconsulting.com, and I can be reached at bill@wfblegalconsulting.com, 949-413-6535 and 949-698-6222. And Rick, for those wonderful videos that you keep doing in support of our show and all of your clients, including me, where can we reach R2?
R2, you can come to our website at r2visualstudios.com. Reach me directly at rick@r2visualstudios.com or 949-667-1182. So.
And how about our social media, Rick?
Oh, absolutely. And the Bottle Business Sense Show, you can find us all over social media, Facebook, Twitter at BB Sense Show, Google Plus, and our website if you want to rewatch this show or re-listen to this show or any previous shows that we've done. You can find an archive of our episodes at bottledbusinesssenseshow.com. So.
Yeah, and as a reminder, before we close today, folks, the archives are something that, we produce this in simulcast, so we're on blogtalkradio.com/bottlebusinessshow if you want to go listen to the audio versions. And we're on our bottlebusinesssenseshow.com site, obviously, and you can go in the archives and rewatch the shows, at your convenience. I mean, you can download shows, listen to them in your car. You can watch a number of our videos anytime you choose. So feel free to go and do that. That's why we have them on there for you. So until next week. Rick, have a great week. I hope our business owners are profitable this week and every week thereafter. And I hope they implement the business tips we provide for their benefit. So until then, we'll sign off. And Rick, I'll see you same time, same place next week, right?
Absolutely, Bill. Look forward to seeing you again next week here on the Bottle Business Sense Show at 10 a.m. So,
okay.
Everyone have a great week. We'll see you soon.
Take care, everybody.